or let me try to figure out how to share my screen, which is always more of the challenge.
Yeah, so the little green button on the bottom should say share screen, and you should be able to press that. And there you
You
go.
can tell that I'm from a team that is used to working with technology, um, because I'm one of the few people who still struggles with Zoom, even after all these years. Uh, my apologies, people. Just give me 30 seconds to figure out how to. We're just going to do it from this way, because when I try and share the other screen, the computer doesn't like it. So with that, I'll get started. My name is Bevan Wharton. I am a part-time professor at the University of Ottawa and counsel at the Department of Justice. Nothing that I say today has anything to do with the Department of Justice or reflects the positions of the Department of Justice, or the positions of the University of Ottawa Faculty of Law. So just to put that little caveat out in advance, and I expect that much of the audience are legal professionals, so you understand that I'm obligated to say that at the outset. But I will say that I've had an interest in apologies as a professor teaching dispute resolution and providing legal advice on dispute resolution for a number of years, because it can be such a critical aspect to resolving any disputes, or in particular, any litigation. So I teach this lecture as part of the course that I teach to second and third year law students at the Faculty of Law at the University of Ottawa. And then a colleague and I have also developed a more formal course that's aimed more at public apologies for the Department of Justice. And the materials that I'm presenting today are part of the materials that would often be presented as either one of those lectures. I'm not sure what the usual process is for people asking questions. My suggestion is that if people have questions as we go along, if you just put them in the chat, and I'll monitor the chat as we go along. It's probably a little bit easier than lifting your hand, because I sometimes miss that from time to time. So with that said, thinking about apologies, some of you may remember For Better or Worse, where Lynn Johnson talks about how an apology is the super glue of life. It can repair just about anything. So that's one perspective on apologies. C.K. Chesterton, a mystery writer from England, also had some thoughts on the apology. A stiff apology is the second insult. The injured party does not want to be compensated because he has been wronged. He wants to be healed because he has been hurt. And finally, if there was ever a chance for us to compare ourselves to our former English colonialists, if an Englishman gets run down by a truck, he apologizes to the truck. And I think this is one of the reasons why when we talk about apologies and apologies in the context of the legal structure in Canada, I think of the Apology Acts and the legislation we have around apologies that exists in most jurisdictions. It really is the most Canadian legislation that has ever been adopted to allow people to apologize without attracting any liability. And this is particularly important because we are living in what I refer to as the age of apologies, or the age of non-apologies. Both in the private and public sector, we see a number of people who are being called upon to apologize, either for recent poor actions or historic poor actions. And because we see these apologies being requested or being offered, we're also seeing an increase in the number of cases that relate to apologies before the courts. And certainly one of the reasons why there is this demand or offering of apologies is because a well-delivered apology can be a very effective either public relations tool, which can possibly limit public relations disasters, but it can also minimize some of the legal consequences that can flow from poor actions that may lead to litigation. That being said, one of the pieces of advice that I often provide to people is to just be aware of the non-apology, because many people will offer apologies with an explanation that can often mitigate the apology so it does not actually sound like an apology in itself. Or words to the effect of, I'm so sorry, or I'm sorry you feel that way, can sometimes actually exacerbate a situation rather than remedying a situation. So when I'm talking about apologies, there are four main types of apologies to consider in a legal context. And the first one is what I refer to as the full apology. I'm sorry, I'm at fault. So it's someone who takes responsibility for whatever has led to the apology. And in some litigation, this has been prior to the Apology Acts being adopted in Canada, and I'll get to that in a moment. Saying I'm sorry and taking any kind of responsibility has been seen as evidence of liability. There are also two lesser forms of apology where someone says, I'm sorry, I regret it, or I regret that this has happened. Or the even lesser acceptance of any kind of responsibility. I'm sorry, I sympathize with this situation. I sympathize that this has happened to you. And all three of those types of apologies can be, although not always are, understood by the law in similar fashions. But we'll talk a little bit about the legal context and what will happen with each types of these types of apologies. The last one of I'm sorry, but not really is the non-apology I was warning about, that these can sometimes exacerbate the situation, that even though the word I'm sorry might be involved in the phrase, it doesn't necessarily mean that it is an actual apology and will be treated as an apology by the courts. When I've done some studying about different looks at apologies, there's also some other types of apologies that more pragmatic people have categorized them. Ones where people are apologizing to gain some credibility or perhaps to influence negotiations. There might be an explanation apology, which can turn into a non-apology at times, where an apologizer might say, I'm sorry, but doesn't accept any wrongdoing and provides an explanation as to why they aren't actually sorry or aren't actually responsible for the wrongdoing. There's also formalistic apologies where an apology is offered without remorse. One of my colleagues refers to this as the my mother told me to apology, or perhaps it is your employer or your manager who tells you to, or perhaps in some cases your legal counsel. And formalistic apology is usually not given much weight by the courts. The happy ending apology, which is one of the ways that there might be some resolution between the parties, in that the apology accepts some responsibility and expresses remorse, and looks to ways to ameliorate the relationship between the parties or to mitigate any kind of possible wrong that has been visited upon them. A mutual expression of sorrow with an interpersonal apology. These are the types of apologies that are often protected in, for example, the medical field. And the idea of a political apology, just getting a statement on the record. And increasingly, especially if you consider some of the apologies that you may have seen on social media, some of these apologies, I would say, are more of a political apology where people want to have something that says, I did in fact offer an apology for this. And well, apologies can, as Lynn Johnson said in her heartwarming cartoons about family relationships, it can repair many things. It doesn't necessarily prevent litigation, and so it shouldn't be looked upon as a panacea. So there's a case that a colleague and I very much enjoy from 1994, which was prior to any legislation that governed apologies in Canada. And it was a defamation case where one party alleged that they were defamed at the university, even though there had been an apology that had been issued by one party to the other. But the reason they ended up in court was because the apology was not issued in the way that the plaintiff wanted the apology to be issued. And so the question for the court was whether or not there was any defamation. And I very much enjoyed what the court said at the end of this course, which was the defendant retracted and apologized on the plaintiff's terms. Had she done so in writing, there would have been no litigation. On the other hand, the plaintiff insisted on a written apology, even though the defendant contained publication by retrieving the copies of the March 9th draft, which is where the alleged defamatory statement was made. And the defendant read this required apology to the ACC members who had received copies. The plaintiff had to realize that litigation would publicize the defamatory words far more widely than the defendant had done. I am unable to say which party was more unreasonable in forcing this case to court. The case should have settled. I award no cost to either party. And as many of you will be aware, certainly awarding no cost to either party is a strong statement from the courts where they say you are both at fault in this particular matter. So at the time that Tatum and Limbrick was being decided in British Columbia, as well as some of the other, there started to be a rise in discussion of apologies in Canadian common law. We didn't have any case law at that time that clearly stated that an apology is evidence of liability. There might have been situations where an apology might be attributed to liability, but it was as part of many other contributing factors. There was also a number of cases that talked about how apologies could be a mitigating factor when an adjudicative body, either a court or a tribunal, was making an award. So they looked, for example, at the timing of the apology, so whether or not it was done shortly after the wrongdoing. They looked at the sincerity of the apology. And again, there's no measure as to whether or not an apology was sincere. So it was based on the subjective analysis of whoever the adjudicator was, either a judge or a tribunal member. They might look at the nature of the apology and whether or not the person took any responsibility for the wrongdoing, or whether it was an expression of sympathy or an expression of regret. And of course, one of the other factors that the court would consider in terms of whether or not an apology was a mitigating factor in any kind of tort or contractual remedy was whether the apology was freely made or whether it was done under direction of another party, either a manager, perhaps legal counsel, or recommendation by a trade union. So at that time, in terms of Canadian common law, there wasn't any case law that said that an apology could be evidence of liability. There was also a significant amount of case law that said that courts or tribunals would not order a party to apologize, that they viewed this as an ineffective remedy and raise potential freedom of expression concerns. So there's a number of cases, largely in the human rights context, but not exclusively, that talked about how the courts and tribunals did not think that ordering an apology was an appropriate remedy. And in a more recent decision, we see why this might come up as one of the issues for the courts and why they would take that approach. In this particular matter, it was a matter of defamation, and the defendant in the case had never accepted that in this particular situation, the plaintiffs were play fighting as opposed to making some kind of derogatory gesture. And it was deemed by the courts that it was unlikely that the defendant would ever actually be able to offer a true apology to the defendants. So even if the apology was published on the defendant's social media, it would only draw further attention to the plaintiffs, which they didn't believe would be in the best interest of the plaintiff. So in order to provide closure, they just issued the decision, and they did not order the defendant to apologize to the plaintiffs in this particular matter. And increasingly, and not increasingly, but certainly in my evaluation of case law, looking at apologies, it is rare, if ever, that an adjudicator will order a party to apologize. There are, of course, a number of risks that we have to consider whenever our client advises us that they are interested in making an apology or want to have your advice about whether or not they should issue an apology. Part of it is an absence of an apology, and not making an apology can be considered as a mitigating factor when it's determined, when the court is determining a penalty. It can lead to higher damages in certain tort actions. It can also determine whether or not a plaintiff decides to commence or continue with litigation in the absence of an apology. However, there's also the possibility that an ill-delivered apology or an apology issued by the wrong person or using language that is considered to be inflammatory might have a further negative effect on the conflict and can exacerbate litigation or lead to litigation. So there's also the ongoing concern that I would say that exists in society in general, and certainly in the legal field, that issuing an apology is considered to be a sign of weakness. It might be considered to be a sign of guilt. And there are some people who perceive that issuing an apology may damage the apologizer's reputation in some way. There's also the apology where there have been certain circumstances recently where someone has apologized. The apology may not have been well received by an individual, and as a result, the apology has been withdrawn by the apologizer, again, exacerbating the situation. So it's important to consider all of those factors in terms of legal and strategic risks when advising your clients about whether or not an apology should be issued, or advising them if an apology has been issued, but also understanding the legal consequences of what may happen if an apology is issued, especially in a jurisdiction where there hasn't been an amendment made to the Evidence Act to allow for an apology to be made without, for example, voiding an insurance policy if it's considered to be an admission of liability. So I'm just going to issue a spoiler alert immediately so that no one in this audience is sitting there on tenterhooks saying, but does Nunavut have this amendment? And the answer is yes. Nunavut is one of the jurisdictions in Canada that does have an apology law, which I'll be going into in the next couple of slides, which does clarify what you can and cannot do in terms of using an apology as evidence. So really what apology laws have done in most jurisdictions is they've clarified what the common law has done. And they've codified it by making it clear when you can apologize, for what you can apologize, and whether or not that will lead to any kind of attraction of liability. So there are some apologies that were already protected by the common law. And we're all aware if you put something in without prejudice letters, that's considered to be protected by without prejudice or possibly by settlement privilege. Same thing for things that are said during mediation. Those cannot be used as evidence of liability in any kind of further litigation. What the apology laws have done is they've really clarified that these cannot be construed as an evidentiary admission. Because in England and Australia jurisprudence, it appeared that the courts in those Commonwealth jurisdictions were heading towards an area where an apology might be considered as evidence of liability. And so what the apology laws have done in those jurisdictions, as well as in Canada, is they allow counsel to advise their clients that they can apologize without attracting any legal liability. Now, that being said, I want to clarify that it's just the apology that is protected, as well as, instead of facts that are apologized, that may be protected by the apology. So if I say, I'm sorry that we have been in this car accident, that is protected. If I say, I'm sorry that we have been in this car accident and it's likely because I have been drinking a lot today, then the fact that I have been drinking a lot that day is a new fact that that could be used as an evidentiary admission in any kind of litigation. So when I was talking to a colleague last night about this presentation, I asked him where he thought apology laws originated, and he suggested Norway. That's actually not correct. I surprised him by telling him that apology laws actually originated in the United States, which is a bit surprising to many of us because we're used to the idea that the United States is a jurisdiction that is fairly litigious. But that is actually where the idea originated. And it has to do with a senator from, if I remember correctly, from Massachusetts, whose daughter unfortunately was killed in a car accident. And there was some litigation that ensued between the family of the deceased young person as well as the person who caused the accident. And at the end of the litigation, the defendant in the matter came and approached the father and said, "Sir, I've wanted to say this since the car accident occurred. I'm very sorry that your daughter has died." And as a result of this, the senator was overcome and said, "If you had said that to me 2 years ago, we wouldn't be in front of the courts." So he looked at the possibility to protect apologies that were made in the context of motor vehicle accidents. So while he was not successful in having that legislation passed, his successor was. And so in 1986, we had our first form of apology legislation that explicitly protected expressions of sympathy or regret in the context of motor vehicle accidents. And what the United States has done since then is in a number of different states, they've adopted some form of apology legislation, usually protecting some form of sympathy or regret, and usually restricting it to one or two different types of legal actions. Usually motor vehicle accidents, as the first law did. Does anyone want to make a guess as to what the other industry or type of tort might be protected? Where might people want to have some protection of an apology that they might issue? I mean, we're Canadian, so it could be bumping into somebody on the street, but Leanne? Medical liability, suggests Carolyn? That's exactly right. It's certainly in the medical field that people are often looking for protection because medical professionals are not monsters. They want to be able to say, "I'm sorry that things have not gone well with this particular surgery," without it necessarily mean that they are attracting any kind of legal liability. So most of the states in the United States that have adopted some form of apology legislation, it is to protect people in the medical field. In Australia, they've had a slightly more broad adoption of what we has originated in the United States. It exists in most jurisdictions in Australia, and it covers most civil actions, but it doesn't protect an admission of fault. So it doesn't have a full apology where anyone says, "I'm sorry, and this is my responsibility." And that's similar with the Compensation Act of 2006, which also contains a provision allowing for parties to apologize without attracting any legal liability. In Canada, it's a little bit different. So in Canada, the first Apology Act was adopted in 2006 in British Columbia. And the then Minister of Justice, who has subsequently been appointed to the bench, stated that apology laws were an attempt to make the civil justice system more accessible, affordable, and effective, and to promote the early and effective resolution of disputes by removing concerns about the legal impact of an apology. So as I said, it was to clarify that when you say you're sorry, that it doesn't mean that you are at fault, but rather that you are in fact sorry, which is one of the reasons why I often say, and as I have said repeatedly already today, that it is a very Canadian legislation, because I am one of those people who apologizes to the door when I run into the door. So the jurisdictions where we have apology legislation in Canada, it includes almost all of the jurisdictions in Canada. So it started with British Columbia. You can see that Nunavut is one of the jurisdictions that adopted apology legislation. And most of the jurisdictions that have apology legislation, they have based it on the Uniform Law Conference of Canada Uniform Apology Act. And I've put a link in the PowerPoint, which I believe the Law Society has either circulated or will make available to participants in today's presentation, so that you're able to look at what the Uniform Apology Act states. And what it does is it gives a template to jurisdictions of what they can do. And in most jurisdictions, it has resulted in an amendment to the Evidence Act to clarify that in civil matters, not in criminal matters, an apology should not be looked upon as evidence of liability. So it's fairly broad in scope. What distinguishes it from many of the apology acts in other jurisdictions is it allows parties in most jurisdictions in Canada to allow for an admission of fault. The exceptions to that is Prince Edward Island, where it has restricted the type of protection to healthcare, and to Quebec, which is one of the most recent jurisdictions to adopt any kind of apology legislation, where they've restricted it to expressions of sympathy and regret. So not, as I would call it, a full apology where there's any kind of admission of fault. It excludes criminal matters, so this only applies to civil matters. It only applies to apologies that are offered before some form of dispute resolution. So that's considered to be mediation or something involving a third party neutral. It does not include negotiation. And it applies to all persons, natural and corporate. So a corporation may issue an apology and be protected in the same way as an individual would be. So one of the questions that I often get is, so what has changed as a result of having these laws in place? And I think some things have not changed dramatically. So for those of you who participate in mediation or other non-binding types of dispute resolution processes, they're still not covered by this legislation. It's still an issue where you would look at settlement privilege that would protect any kind of apology that might be issued as part of a dispute resolution process. But since the legislation has been introduced in most jurisdictions in Canada, we do have a set of principles that we're able to follow and understand in jurisdictions where there is an apology act that has amended the Evidence Act or the Rules of Civil Procedure, as they did in Quebec. And it has clarified the law so that apologies are clearly not evidence of proof of liability, which doesn't mean that the apology that is issued by someone is given absolute protection. It just means that it can't be used as evidence of liability by the parties. Where there has been, in my view, not enough case law or clarification by the courts has been, what is an apology and what is a statement of fact? And where does the apology end and a statement of fact begin? Because I think one of the things that is always a concern is an apology is inadmissible, but what about the statements that follow it? So in the example that I gave earlier in a motor vehicle accident, if I say, I apologize, I can't believe we've been in this accident. If I then go on and make a factual statement about how I've been drinking alcohol for a period of time earlier in that day, is the admission that I have been drinking alcohol part of the apology, or is that a statement of fact? So we have a little bit of guidance in an Ontario decision from 2015 where they really say that what you have to go through is a contextual analysis of the words used and whether or not, as to whether or not something is actually an apology or whether or not something is a statement of fact. And so they really did go through in that decision, parsing it word by word to see what constitutes the apology, where the apology ends, and then what after that is a statement of fact. Because, of course, statement of facts are not protected by the Apology Act, and they can be seen as evidence of liability or used as evidence of liability under the various jurisdictional evidence acts. So there's other decisions. So, for example, there was a labor relations decision from 2019 from British Columbia, where they say, again, similar to what they said in Cormack and Charmos, that you take a fair and large and liberal construction and interpretation of apology legislation. So they really look at exactly what constitutes a statement of fact and what constitutes an apology. And I wish there was more case law on this. I'm not suggesting that anyone does anything with their client that requires them to develop the case law in this area, but it is something that I'm interested to see more development of this area to clarify when does the apology end and when does the statement of fact begin. Because often when we issue an apology, it's not just one sentence. It's often the equivalent of several paragraphs of information. And this is why, if we're not offering a spontaneous apology, one of the things that I always suggest to legal professionals is that it's important to understand the facts before issuing, especially issuing a public apology. So first of all, to think about what type of an apology should be issued. Should it be an apology where there's some aspect of responsibility that has been taken for the wrongdoing? Should it be an expression of regret or an expression of sympathy? What are the facts that are known about the incident that has led to the need for an apology? One of the things that your client or you may want to be concerned about is not disclosing any new facts as part of that apology. Now, that doesn't mean that you can't include facts in any kind of an apology, but they should be facts that should be known by all of the parties. You should also be aware of the distinction between an apology and a factual admission, and think about parsing out the words as to what would be the apology and what would be a factual admission. And be careful about any factual admissions that would accompany an apology, because you don't want it to lead to any further legal liability. So other legal principles that have been established by a number of different cases in the past couple of years. So for example, an apology cannot be given any weight by the courts when determining liability. Apologies in jurisdiction where there is an Apology Act in place will be struck from any pleadings. It doesn't apply to apologies that were issued before the Apology Act was enacted and there was an amendment to either the Evidence Act or the Rules of Civil Procedure. It must be an actual apology rather than a statement of fact for the Apology Act to apply. And while apologies will continue to be considered by the courts as a method of reducing a penalty, it's only if a reduction is possible. And in some cases, we have strict liability, so that if somebody drives over the speed limit, there is an automatic penalty. And even if an apology is deemed to be sincere, there's no way to reduce the penalty if the penalty is a strict application of, if you've done something wrong, this is the penalty that must apply. So it can be of assistance, but it is not, as I said, always an absolute protection. So we're at a little bit over the half-hour point. I have a couple of things about how to apologize and how the courts are looking at the sincerity of apologies. Any questions at this point? Please don't worry that you're not getting to participate, because I have an exercise at the end. I can see everyone getting very excited at this point. Okay, so I'll continue onwards, but if there's any questions that arise, don't hesitate to put it in the chat. So when we talk about methods of apology, I've certainly read a lot of social research as well as legal textbooks and case law. And I would say that there's no set best method to apologize. There's no specific wording that is the magical wording that you need to have in order for an apology to be treated with weight by the courts or well received by the other party. The courts are going to evaluate the sincerity of an apology. They won't order how it has to be delivered, whether it has to be delivered verbally or in writing or published electronically. And there's a number of recent cases that have emphasized those points, that there's not just one way to deliver an apology. There's also not just one way for the courts to deem whether or not an apology is considered to be sincere. If it's not sincere, it won't be given any weight and might be considered to be worthless. And some factors that might be considered by the courts, whether or not the apology has been delivered only because wrongdoing was discovered, whether or not it was because the apology was forced, someone told the person to apologize, or if the apology is deemed to have been offered only to mitigate a particular penalty. And I offered some cases that you're welcome to look at there. My favorite one is, of course, the one involving my former evidence law professor in Alberta with the Law Society. Oh, okay. With the Law Society of Alberta, where in the initial instance of this particular matter, where it was a contempt matter with someone who had been disbarred as counsel, with a question as to whether or not this person was deemed to be sincerely apologizing, the court didn't deem that the apology was sincere, as they didn't in these other apologies, because it was mostly because the person was caught doing wrongdoing that they issued the apology, not because it was actually deemed to be an expression of remorse or actually being sorry. So that also takes us to receiving apologies, because when someone issues an apology, there's no obligation on the other party's part that they have to accept the apology or forgive the person who is issuing the apology. And this can lead to some complications, especially if you are representing the person who's issuing the apology, because their position is often, I'll only issue an apology if it's going to be accepted by the other party. So there certainly have been situations where parties have negotiated what should be included in an apology. But there's no obligation, even after those negotiations, that the person who's receiving the apology has to accept it or has to forgive. And so this can be one of the considerations for legal professionals when they're advising their client about issuing an apology or perhaps receiving one, because there may be a number of different factors that will affect how an apology is received. So part of it is understanding the framework of apology laws. So is there an Apology Act in place in your jurisdiction? And there is in Nunavut, but not in every place where everyone on this in this meeting may be practicing. Especially for those of you who are practicing in the federal jurisdiction, just so you're aware, there's no amendment to the Canada Evidence Act that allows for an apology to be made without attracting legal liability. Now, this doesn't mean that apologies issued in federal jurisdiction will attract legal liability. It just means that the Canada Evidence Act has not been clarified in the same way that most provincial and territorial jurisdictions have had the law clarified. And just remember that if the apology is not issued on the terms of the person receiving the apology, they may just reject it, not because of the content of the apology, but because of who is making the apology or how the apology is being issued. So these can all be important considerations. And certainly in public apologies, there have been situations where parties have rejected the apology either from a government or from a corporation because it wasn't issued in writing or issued by the correct person or issued in the correct manner based on the people who are receiving the apology and what they wanted to receive. Which makes it important to consider various cultural considerations. So the timing of an apology is important. If the apology comes long after the act that led to the need for the apology, it can be too long and can be considered rehearsed. But if you're looking at a historic wrong or something that has not immediately emerged, you may need to consult with the party that feels that they require an apology, because you want to make sure that it is properly and appropriately delivered. That might mean in a public forum, that might mean in a private forum, that might mean both. And there are certainly situations with apologies that have been issued by universities where they've been apologizing for denying admission to certain parties. So in particular, I'm thinking of Queen's, where they had to make an apology because they had a historic wrong of denying admittance to Black students to study medicine. So they didn't immediately, upon this being brought to their attention, apologize. They carefully consulted with a number of stakeholders before issuing the apology and deciding what would be the correct course of action to try and ameliorate the situation, which included including information in the curriculum, as well as including information as a public display at Queen's, and starting scholarships for Black students to try to increase the number of Black doctors that were being trained in Ontario. There's also questions as to who should issue the apology. And there are some people who want the apology that is issued by the perceived wrongdoer. So I'm thinking more of workplace situations where someone might want a manager to apologize for not correctly applying certain rules or regulations. But sometimes that's not appropriate, and we end up with an apology that is not deemed to be sincere since someone is ordered to make an apology. And it might be better that it's done by a senior official who's apologizing on behalf of the organization rather than the person who might have done the wrongdoing. Another issue that is quite common in Canada, especially when dealing with Indigenous people or locations where English may not be the prevailing language, is the language of the apology. Should the apology be issued in more than one language? If the person who is initiating the apology is only able to apologize in either English or French, should they provide a written copy of any kind of an apology in an additional language? So for example, in a variation or the appropriate variation of Inuktitut. Should it be in writing? Should it be in person? And a big consideration for many parties is it published? Can I find a record of this apology at some point in the future? And this has been particularly true about apologies that have been issued by public sector organizations. Some parties have made it very clear that if it is not on Hansard, they do not consider it to be an official apology, even if it has been made by the Prime Minister in another location. Because there is not a formal written record of said apology, they may consider it to be insignificant or not an actual apology. So we actually have a situation in Canada with two public apologies that have been issued for the same incident, something called the Kamagata-Maru incident, where people who were trying to immigrate from India arrived on the coast of British Columbia and were refused entrance, or in fact were refused initially to be allowed to disembark or even receive any water, on the basis that there was a piece of legislation at the time called the Continuous Journey Act, and they had stopped on their way to arrive to Canada. So they were not deemed as people who were allowed to come to Canada. We have an apology that was issued by Prime Minister Stephen Harper in Surrey, in British Columbia, near where the Kamagata-Maru incident had happened almost 100 years before. This was deemed not to be an acceptable apology because it wasn't on Hansard. So several years later, Prime Minister Trudeau apologized for the same incident in the House of Commons, and this placated many people, in part because there's now a Hansard record of this apology, which goes back to the issue of consultation. So for those of you who are involved in litigation at the moment and wondering whether or not you can apologize, or whether or not your client can apologize, yes, you can always apologize mid-litigation, but you should always ensure that the litigation team or the litigator is aware of the client's intent to apologize and might have some say in the content of the apology. You don't want to make the apology so broad that it defeats or overly limits any kind of litigation strategy. And one of the questions that has often arisen when I've been asked about this is, could the matter be settled if the client wants to apologize? Is this something that could be ripe for settlement as opposed to ongoing litigation? And apologies are certainly being considered as portions of these settlements. Apologies are leading to settlements and are often being referred to in settlements, particularly in class actions most recently. So we've seen this in the resolution to the 60 Scoop class action settlement, that they actually referred to the apology that was given by the Prime Minister. We also have a situation where there was a proposed class action regarding the LGBT purge of gay employees or LGBT asterisk employees within the federal government. And there was a reference to the settlement. And most recently in the First Nations and Child and Family Services, Jordan's Principle and Trout class action settlement, dealing with a Canadian Human Rights Tribunal issue about underfunding of on-reserve family services. And they refer to a prospective apology that will be issued by the government in the future as part of the settlement between the parties. So these are just examples where there is a discussion of the apology as an important component of the settlement of any kind of ongoing litigation, often in class action litigation. But we also see examples where there's a rejection of a settlement, sometimes on the grounds that there isn't a sufficient apology that has been offered to the members of the class. And there's a mention of that in a decision from Ontario where the members of the class were offended that the terms of settlement don't provide for an admission of liability or for an apology. And it was for this and other reasons that the settlement was actually dismissed by the courts. And I refer to you to the an obiter note at paragraph 80. I note that unlike other institutional abuse settlements, there's no provision for the defendant to apologize. In my view, this is unfortunate. The cost is minimal, but the returns for the dignity and healing of the Crown wards would be substantial, which just goes to show you that courts really do think that a well-issued apology can have that healing effect to parties involved in litigation, particularly historic actions. So in terms of what are your legal, professional, ethical obligations about apologies, you have an obligation to provide your clients with appropriate legal advice. So details of how to deliver the apology, how, when, and to whom, the risks of delivering an apology or not delivering an apology, but you do not have an obligation to issue an apology on your client's behalf. It can be delegated to counsel by your client, but that is often less effective than your client actually apologizing. And based on the Code of Professional Conduct, and I've referred to the Federation of Law Societies Model Code, this includes understanding the requirements of integrity, competence, honesty, and candor. And I would say in particular, encouraging compromise and settlement would be the ones that I would refer people to in terms of your obligations. So with some final practical tips, time any apologies correctly, phrase any apologies correctly. You want to make sure that it is within the confines of what is protected by relevant apology legislation, or advise your client if the apology issued is not within the confines of the relevant apology legislation. It should be a sincere apology if you want it to carry any kind of weight and be accepted by both the person receiving the apology as well as by the courts as a mitigating factor. So last couple practical tips. Make sure that you recognize that the event that the harm is caused, recognize the event that caused the harm. Where possible, take responsibility for the event and the harm caused. Express regret or remorse. One of the things that I think is often important for any kind of assurance to the parties is whether or not anything has been done to make sure that the event will not recur. So perhaps some training for the parties involved, perhaps some changes to legislation, perhaps some changes to corporate mechanisms, perhaps some changes in terms of how any kind of business is run, and consider what restitution might be appropriate as a result of the harm. Although I note that restitution does not actually necessarily have to include financial restitution. So sorry, that's a double slide, my error there. And then I have a very short oh, thank you, Judith. I just saw there's someone who's had to leave. I have a short exercise in the last 5 minutes that we have in this time. If your client is a small automotive repair shop that has been accused by a car owner of making costly but unnecessary repairs to many vehicles, your client advises that one mechanic who has since quit working at the shop appears to have been doing this regularly, and you have only just discovered this. So what would be an acceptable legal approach? First of all, A, an apology is evidence of liability. Say nothing. B, write a letter apologizing to all clients and admit to all wrongdoing. The statements cannot be used in litigation. Or C, write a letter apologizing to the litigant and offer to settle. Any suggestions for what would be an appropriate exercise given what I've covered about apologies? C would certainly be an acceptable method to do so. And again, an offer to settle doesn't necessarily have to involve any kind of financial compensation, although it may based on the facts in this particular scenario. If this is occurring in Nunavut, the situation would be protected by the Evidence Act that's applicable in Nunavut. So there would be a framework that protects any apology that is issued. Do you want to write a letter apologizing to all clients? Perhaps not. It might be a strategy, but more of a public relations strategy, I would suggest, rather than a legal strategy that you may want to have. The statements may or may not be used in litigation. Only the apology would be protected. Any factual statements would not be protected in the letter that you write to all clients. So that would be something that you would have to keep in mind. And then I have one more short exercise. Your client is a large corporation. One of the employees almost ran over the foot of a protester while the employee was in the process of moving heavy objects with heavy equipment. The employee immediately ascertained whether the person was injured and apologized profusely. The protester, who was technically on public property when they were at the entrance to the business, has threatened to sue and is using the employee's apology, which they recorded on their phone, as everybody does now for almost everything, as evidence of wrongdoing on your client's behalf. Are you particularly worried that the client has issued an apology? Is that evidence of wrongdoing? Any thoughts on that? So in this particular scenario, I would say that what would concern me the most is that the protester has been filming this on their phone. And it would be more the injury to the protester as opposed to whether or not the employee has apologized or not. The apology itself is not something that would concern me in this particular situation. But you might need to look at whether or not an apology from the corporation would be something that might be appropriate as any kind of discussions with the protester who has been injured by the employee of the company. I don't think that the employee would have to be particularly worried, but the corporation may have to be worried that somebody has been injured. I don't think they need to be worried that an employee has apologized. That's a pretty common thing that happens and would be protected by the legal framework that exists in Nunavut and most other jurisdictions. So I think we've come to the end of the time, but I'm still going to leave it out there for any questions that anyone has. I don't see anyone taking themselves off mute. Okay, so I appreciate everyone's attention. I know that our time as legal professionals is often short. If anecdotally you wish to contact me at any time, I'm available both at the University of, probably the easiest place to get a hold of me is always at Justice, where I'm happy to comment anecdotally about issues, but not offer any legal advice. Sorry, I'm just trying to put it into the meeting and just realized that I have so I'm happy to provide more information based on the more in-depth training that I offer to students at the University of Ottawa, or you're welcome to contact me at Justice, where I will be very happy to say that anything I say does not actually constitute or represent anything or any position of the Department of Justice. But those are the two email addresses where I'm most likely to respond if anyone has any further questions or follow-ups. So a big thank you to Rebecca Bromwich for inviting me today, and to Santana for setting everything up.
Thank you so much for presenting today. It was a great topic, and I think everybody enjoyed it very well. If you are having any issues downloading the slides from the website, I am currently fixing this. And if you would like a copy, please do not hesitate to reach out to me, and I will send it to you via email. Thank you again, Bevan.
Okay, thank you to everyone here.